Good afternoon, everyone. Welcome to this lecture series on the rules on evidence. This afternoon, we will discuss about testimonial evidence. So let me share my screen with you. Okay. Rule 130, testimonial evidence. What are the qualifications before a person can testify in court? One, the person must he must have the ability to perceive and is perceiving. In other words, he can perceive and is perceiving. Number two, he can make known their perception to others. And number three, he must not possess the disqualifications imposed by law or the rules. So these are the three qualifications of a witness. So you will notice that the qualifications are quite basic. A witness, no, a person can be a witness as long as he can perceive and is presently perceiving. And not only that, he must be able to communicate this perception to another, and he must not be disqualified by the rules or the law. Now, a prospective witness must show that he has the following abilities. Number one, to observe the testimonial quality of perception. Number two, to remember the testimonial quality of the memory. And number three, to relate the testimonial quality of narration. And fourth, to recognize a duty to tell the truth or the testimonial quality of sincerity. In other words, class, otherwise stated, there are four qualifications or qualities of a testimony or a witness. The witness must have the ability to perceive, or what we call the quality of perception. He has the quality of memory. He has the quality of narration, and his testimony must be genuine or sincere. Now, how do we distinguish between competency and credibility? No? How do we compare when a witness is competent and a witness is credible? A witness is competent if the witness possesses the basic qualifications of a witness, no? As his capacity to perceive and his capacity to communicate his perception to others. Now, credibility pertains to believability or the weight of the witness and has nothing to do with the law or the rules. So you have their competency, the basic qualification, meaning the minimum requirements before a person can be admitted as a witness, whereas credibility refers to whether the testimony of the witness can be believed or not. Now, as a general rule, a person who takes the witness stand is presumed to possess the qualifications of a witness. In other words, class, every person is presumed to possess the qualification of a witness. There are certain exceptions. One, the fact that a person has been recently found of unsound mind by a court of competent jurisdiction. Or number two, that one is an inmate of an asylum for the insane. Okay. Now, what are the disqualifications of a witness? In other words, when do we know when a person may not qualify as a witness? Number one, he is disqualified by reason of mental incapacity or immaturity. Number two, disqualified by reason of marriage. Number three, disqualified by reason or death of insanity of the adverse party. And fourth, disqualified on the ground of privilege communication. Let us go to mental incapacity. No? A witness may not qualify or a person rather, may not testify in court if he is having if he is having a mental incapacity or mental immaturity. What do we mean when we say mental incapacity? Mental incapacity is that whose mental condition at the time of their production for examination is such that they are incapable of intelligently making known their perception to others. Take note, class, that the mental incapacity, which is referred to as a disqualification of becoming a witness, refers to such time that the witness is to testify, which is why you will have there at the time of their production for examination. So much so that if the witness is mentally incapacitated at the time that he witnessed or he saw the incident subject of his testimony, but at that time that he is to be produced in court or his testimony is to be given in court, he is of sound mind, then he is qualified as a witness. Again, the mental incapacity which is referred to pertains to the incapacity at the time that the witness is to be produced for examination and not at the time that the witness was able to see or the witness was able to acquire personal knowledge of the circumstances of the testimony. Now, let us go to immaturity. Immaturity means children whose mental maturity is such as to render them incapable of perceiving the facts respecting which they are examined and of relating them truthfully. So I think that's self-explanatory. Okay. What are the requisites for a witness to be disqualified under this rule? The proposed witness must be incapable of making known his perception to others. And second, the incapacity must exist at the time of his production for examination. What about disqualification by reason of marriage? Now, the purpose why this rule has been included is that it forbids one spouse to testify for or against the other spouse based on principle which is to preserve the marital relation or the marriage relation as one of full confidence and affection, and that this is regarded as more important to the public welfare. So class, a spouse may not testify for, meaning in favor or even against the other spouse. This is to preserve their marital relation. Now, as a general rule, class, during their marriage, the husband or the wife may not testify for or against the other without the consent of the affected spouse. Okay, so the only exception here, or the obvious exception here is with the consent of the affected spouse, then the other spouse can testify. But without consent of the affected spouse, the other spouse may not testify either for or against the other spouse. There are certain exceptions. Number one, in a civil case by one against the other. So if the civil case is filed by the spouse against the other spouse, then obviously the complaining spouse can testify against the other. Number two, in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. So if what was filed is a criminal case by the spouse against the other spouse, for example, a crime or a complaint for the prosecution of adultery, concubinage, or bigamy, this is filed by one spouse against the other, then that complaining spouse, as an exception to the general rule, can testify against the other. Now, number three is where testimony was made outside the marriage. Okay, what are the elements of the application of the rule? Number one, the defendant in the case is the executor or administrator or representative of the deceased or the person of an unsound mind. Number two, the case is against the executor or administrator or a representative of the deceased or the person of the unsound mind. So class, these are the elements of disqualification by reason of death or insanity of the adverse party. If the adverse party has died or he has become insane, then the defendant in the case is so then you are not allowed to testify based on facts pertaining to the insane adverse party or the deceased adverse party. So these are the enumeration of the elements. No? Take note. One, the defendant in the case is the executor or administrator or the representative of the deceased or the person of unsound mind. Second, the case is against the executor or administrator or representative of the deceased or of the unsound mind. Okay. Third, the subject matter of the action is a claim or demand against the estate of a deceased person or a person of unsound mind. And fourth, the testimony is as to any matter of fact occurring before the death of such deceased person or before such person become of unsound mind. What about, so in the same rule, disqualification by reason of death or insanity of the adverse party. The disqualification under this rule is waived if the defendant does not timely object to the admission of such evidence or testifies on the prohibited matters or cross-examines therein. So this is the exception. For example, the witness is to testify on matters occurring before the death or insanity, but the other party or the adverse party did not make an objection, no, a timely objection to the admission of such evidence, then the disqualification or the right to invoke the disqualification is deemed as waived. Now, what are the cases covered by the disqualification by reason of death or insanity of the adverse party? It constitutes a partial disqualification of a witness, wherein he is prohibited from testifying as to any matter of fact occurring before the death or insanity of a party to the transaction. Take note that the witness cannot testify on matters which occurred in the presence and within the hearing of the decedent, to which he might testify on his personal knowledge if he were alive. Facts favorable to the deceased or an insane person or the representative are not prohibited. Take note, so those facts which the witness can testify, which is favorable or which is in favor of the deceased or the insane person, is not prohibited. So what is prohibited is a testimony adverse to the insane person or to a deceased adverse party. Okay. What are cases not covered by the disqualification by reason of death or insanity of the adverse party? Number one, testimony of mere witnesses who are neither party plaintiffs nor assignors, nor persons in whose behalf a case is prosecuted, nor to a nominal party, nor to officers and stockholders of a plaintiff corporation. In other words, class, the first exception is pertaining to a witness who is not a party to the case. Either that he is not a party to the case, or he is not an assignor, or he is not an officer or stockholder by a corporation who is the plaintiff in the case. In other words, the witness is in no way related to the plaintiff or the assigner or the plaintiff corporation. Okay? So if the witness is not a party, he is not a party plaintiff, he is not an assigner, he is not an officer or stockholders of the corporation, then he can testify. The disqualification will not apply. Now, if the person or persons mentioned under the rule file a counterclaim. Okay. Number three, when the deceased contracted with the plaintiff through an agent and the said agent is alive and can testify, but the testimony of the plaintiff should be limited to acts performed by the agent. Number four, land registration cases instituted by the deceased representative where the oppositor is considered as defendant in or in cadastral cases where there are no oppositors. Number 5, when there is waiver. Number 6, if the plaintiff is the executor or administrator of another representative of a deceased person or the person of unsound mind. 7, when the testimony refers to fraudulent transactions committed by the persons mentioned in the rule, provided such fraud is first established by other evidence. 8, negative testimony, that is testimony that a fact did not occur during the lifetime of the deceased. 9, testimony of the present possession by the witness of a written document signed by the deceased because such facts exist even after the death of a decedent of decedent. 10, when the defendant through heirs of the deceased are sued in their personal and individual capacities. And 11, in action against partnership. In all these instances, class, they are not covered by disqualification by reason of death or insanity of the other party. What about disqualification by reason of privileged communication? Now, what is privileged communication? Now, normally, these are communication which are covered by a special relationship, which is considered by law as a privileged relationship. Like, for example, the relationship between doctor and patient. Now, this is covered by the rule on privileged communication. The relationship between a lawyer and his client is privileged, such that the lawyer may not disclose certain information respecting his client. No? What else? The priest confessor privilege. The what else? The a news correspondent and his source is also an example of a privileged communication. No, the disqualification applies both civil and criminal cases, except as to doctor-patient privilege, which is applicable only in civil cases. So class, the doctor-patient privilege does not apply to criminal cases. Say, for example, if the doctor has committed medical malpractice, the patient can file a complaint for reckless imprudence or simple imprudence, as the case may be. So if the case filed by the patient is a criminal case, then the doctor-patient privilege will not apply. Now, the following persons cannot testify as to matters learned in confidence in the following cases. So these are the enumeration of the privileged communication. Number 1, husband and wife. Number 2, attorney and client. Number 3, physician and patient. Number 4, priest and penitent. And number 5, public officers. Let us go to the privileged communication between husband and wife. What are the requisites for the application of this privileged communication? Number 1, there must be a valid marriage. Number 2, the privilege is invoked with respect to a confidential communication between the spouses during the said marriage. And number 3, the spouse against whom such evidence is being offered has not given his consent to such testimony. So class, before the husband and wife communication privilege must apply, the marriage must be valid and that the confidential communication transpired during the said marriage and the spouse against whom the evidence is being offered did not give his consent to such testimony. So what about those instances wherein the husband and wife communication privilege may not be invoked or does not? What are the cases wherein this privileged communication do not apply? Number 1, again, in a civil case filed by one against the other. Or number 2, in a criminal case for a crime committed by one against the other. Or the latter's direct ascendants or descendants. Do you know, class, what is the distinction between direct ascendant or descendants, and collateral relatives. Diba you know that? Indirect ascendants or descendants, you are coming from a common ancestor. While if it is a collateral relative, then these are your first cousin, second cousins. No, they are your they are not, they don't belong to the direct line. Okay. Now, as a general rule, third persons who without knowledge of the spouses overhear the communication are not disqualified to testify. So for example, if two spouses are talking to each other in confidence, but it was overheard by a third person, that privileged communication will not apply as to the third person. Now take note of that. The third person who was able to overhear the communication is not disqualified to testify, because the privileged communication between the husband and wife applies exclusively to them. Exception: when there is a collusion or voluntary disclosure to a third party, that third party becomes an agent and therefore he cannot testify. What about the privileged communication between an attorney and client? What are the requisites for the application of this privilege? Number one, there is attorney-client relationship. Number two, the privilege is invoked with respect to a confidential communication between them in the course of professional employment. And number three, the client has not given his consent to the attorney's testimony, or if the attorney's secretary, stenographer, or clerk is thought to be examined, that both the client and the attorney have not given their consent. So take note, in the privileged communication between an attorney and client, the communication must be given in confidence. In other words, before this privileged communication apply, there must be a confidential communication. When you say confidential communication, there is a reasonable expectation of privacy, which is why, class, sometimes you will be tuning into some television programs wherein some lawyers will give their advice online or even on air. Diba? You have watched some TV programs like that. So if the advice was given on air or online, then I would presume that the attorney-client privilege communication will not apply, because that advice can be hardly considered as a confidential communication. How can that be a confidential communication when it was communicated in public in the first place? So in the absence of confidential communication between the client, the attorney and client, then there can be no privileged communication to begin with. Take note also, class, that if the person to be examined is not the attorney, but his secretary or his stenographer or clerk, then the consent of both the client and the attorney must be secured. Okay. Now, what are the instances wherein the attorney and client privilege communication does not or do not apply? Number one, it is intended to be made public, just like the earlier example. Number two, it is intended to be communicated to others. So for example, class, the client of the lawyer is composed of the board of directors of the corporation. Then that advice by the lawyer is intended or is ought to be communicated to the rest of the board of directors, and therefore the attorney-client privilege will not apply. No. Number three, it is intended for an unlawful purpose. So if the advice of the lawyer is intended to commit a crime, for example, then the attorney-client privilege will not apply. Or, for example, the client went to the lawyer and the client wants to consult about the commission of the crime of terrorism. Or for example, he wanted to bury the evidence by distracting pieces of documents. Will the attorney and client privilege apply? The answer is no. Because if the communication made either by the lawyer or by his client is intended for an unlawful purpose, then the privilege communication will not apply. In other words, the lawyer or the client is not bound to observe the absolute secrecy of this communication, or the absolute confidentiality rather. Absolute confidentiality of the communication. Absolute secrecy is more of banking laws. Okay. Now, for receive from third persons not acting in behalf or as agents of the client. So if the communication is received from a third person other than the client, then the privileged communication will also not apply. Or number 5, made in the presence of third parties who are strangers to the attorney-client relationship. What is the test in applying the attorney-client privilege? Okay. The test is whether the communication made is with the view of obtaining from the lawyer his professional assistance or advice, regardless of the existence or absence of a pending litigation. Let us go to physician and patient communication privilege. What are the requisites for the application of this privilege? Number 1, the action involves a civil case. Take note, class, that the physician-patient communication privilege will not apply to criminal cases. Number 2, the relation of a physician and patient existed between the person claiming the privilege or his legal representative and the physician. Number 3, the advice or treatment given by him or any information was acquired by the physician while professionally attending to the patient. 4, the information was necessary for the performance of his professional duty. And 5, the disclosure of the information would tend to blacken the reputation of the patient. Now, the physician and patient privilege communication does not apply to the following instances. Number 1, where the communication was not given in confidence. Number 2, it is irrelevant to the professional employment. Number 3, it is made for an unlawful purpose. Like for example, a certain convict, no, who observed the sentence of imprisonment, went to a dermatologist, no, and he wanted to bury his identity. He wants to change his face from one person to another in order to hide his criminal conviction, or worse, to assume a person that he is not, or not a person, to assume the identity of the person that he is not. So if the communication is for an unlawful purpose, then the doctor is not bound by the confidentiality of the communication. As a matter of fact, it is the duty of the doctor, it now becomes the duty of the doctor to report it to the lawful authority or the police authority. Okay. Number 4, it is intended to be made public or it is waived either by contract or by law. Okay. What are the pieces of information which the doctor cannot disclose? Number 1, the advice or treatment given to the client. So for example, you cannot ask the doctor what is the kind of health issue that the patient have consulted the doctor for, or the doctor may not be examined what kind of treatment or operation that he has performed to the patient, not the client, the patient, no? And then number 2, any information acquired in attending such patient, provided that the advice, treatment, or information was made or acquired in a professional capacity and was necessary to enable him to act in that capacity, and the information sought to be disclosed would tend to blacken the reputation of the patient. Let us go to priest and penitent. What are the requisites for the application of this privilege? Number one, the confession must have been made to the priest in his professional character according to the discipline of the church to which the priest or minister belongs. So assuming that the person has confessed a crime, the commission of a crime to the priest, and this priest happens to be the childhood friend of the person who has committed the crime, and they were having a drinking spree. And what the person who has committed the crime did is to confess the commission of a crime to his childhood friend, who turned out to be a priest. And then later on, the priest was required to testify in a criminal case for the prosecution of such crime. Question, can the priest invoke the privileged communication between the priest and penitent? The answer is no. The privileged communication applies only if the information was obtained in the professional character or that the priest is in the performance of his duties according to the discipline of the church to which the priest or minister belongs. And second, communications must be confidential and must be penitential in character, example, under the seal of a confession, no? Because confession is one of the sacrament in the Roman Catholic Church. So if in case that there is a confession between the priest and penitent, this is likewise covered by the privileged communication. The priest may not be compelled to testify against the penitent. No? Okay. What is the purpose of the priest and penitent privilege? This is to allow and encourage individuals to practice their religious belief, not to fulfill their religious, emotional, or other needs by protecting confidential disclosures to religious practitioners. So this privilege does not apply when the communication is not penitential in character, as when it is disclosed or when what is disclosed is a plan to commit a crime. So for example, lumapit yung ano bang tawag diyan sa pare at saka yung nangungumpisal. Lumapit yung nangungumpisal sa pare at sabi niya, "Father, mamayang gabi ay papasok ako sa simbahang ito at kukunin ko ang chalice." O kaya yung corona ng ginto, 'di ba? O naman sabihin ng pare ay hindi ito covered ng privileged communication because the communication is pertaining to a plan to commit a crime. By the way, what if what was confessed by the penitent is a past commission of a crime? What about a crime which was committed in the past? Can that be disclosed by the priest? Answer, no. Not the only exception here is when what was disclosed rather is a plan to commit a crime which is futuristic or in the future. So when what was confessed is about a crime which was committed in the past, then the priest may not disclose the information. Public officers. Requisites for the application of this privilege: the communication must be made to a public officer, that it was given in confidence, and number 3, the public interest would suffer by the disclosure of the communication. This privilege does not apply if what is asked is useful evidence to vindicate the innocence of an accused or to lessen the risk of false testimony. Third, essential to the proper disposition of litigation, or the benefit to be gained by a correct disposition of the litigation was greater than an injury which could inure to the benefit to the relation rather by a disclosure of information. What about parental and filial privilege? No person can be compelled to testify against his parents, other direct ascendants, children, or other direct descendants. So this is what you call as parental and filial privilege. And then there are other privilege matters under the rules of court. The guardian ad litem shall not testify in any proceeding concerning any information, statement, or opinion received from the child in the course of serving as a guardian ad litem, unless the court finds it necessary to promote the best interest of the child. Second, editors, publisher, or duly accredited reporter of any newspaper, magazine, or periodical of general circulation cannot be compelled to reveal the source of any news report or any information given to him in confidence unless a court or a house or committee in Congress finds that such revelation is demanded for state security. Number 3, voters may not be compelled to disclose for whom they voted. Number 4, trade secrets cannot be disclosed, although this is not absolute, as the court may compel disclosure when it is indispensable for doing justice. 5, bank deposits are absolutely confidential in nature, except upon written permission of the depositor or in cases of impeachment or upon unlawful order of the competent court. Actually, class, when you go to banking laws, the exceptions to absolute confidentiality of bank deposit differs in peso account and in foreign currency account. Kasi in peso account, there are several exceptions to absolute confidentiality aside from written permission of the depositor, such as in cases of impeachment, lawful order of the court, in case of garnishment, in case of robbery. There are several exceptions. On the other hand, in foreign currency deposits, there is only one exception, and that is the written permission of the depositor. So in other words, class, impeachment cases is not an exception to foreign currency deposit, no? Unlike in peso deposit. Number 6, conciliators and similar officials shall not testify in any court or body regarding any matter taken up at the conciliation proceedings conducted by them. And number 7, informers for the protection of their identity cannot be compelled to testify by the prosecutor when the testimony would be merely cumulative or corroborative. What about class a child witness? The Supreme Court has promulgated the rule on examination of a child witness. So class, when a child is presented as a witness in court, you have to observe a different set of rules. The examination of a child witness presented in a hearing or any proceeding shall be done in open court, unless the witness is incapacitated to speak or the question calls for a different mode of answer. The answers of the witness shall be given orally. Now, the party who presents a child witness or the guardian ad litem of such child witness may, however, move the court to allow him to testify in the manner provided in this rule. So, class, usually, pag ang witness ay bata, no, a child or a minor, usually they don't take the witness stand. What the judge does is there is a room, a special room for child witnesses. The child will be brought to that room, and then the proceedings will be less formal. And as a matter of fact, what I remember is that the judge is not required to wear his robe so that the child will not be intimidated, no, by the posture or the appearance of the judge and the lawyers. And that the lawyers may not pose questions directly to the child witness, but the lawyer will ask the question to the judge first, and then the judge will ask the question directly to the child. So that is the rule on examination of a child witness. So we end here. I'll see you again next week.